Now, legal analyst and director at Makangela Mtungani Inc, Sinawo Makangela, joins us to discuss the Senzo Meyiwa case resuming tomorrow, possibly with a new judge, as was stated. Thank you very much for joining us this evening. So at the last sitting, as stated, Deputy Judge President Aubrey Ludwaba announced that the trial has been set down for a whole term with a new judge, Judge Mohlakeng. How much of an impact will the change of a presiding officer have on the case at this point? Is it likely to start afresh?
Thank you for having me. Good evening to the viewers as well. Well, I think let's give credit to the Deputy Judge President for taking leadership to ensure that this long-awaited trial at least must have a direction. Now that the presiding judge has, in fact, now that they now know the presiding judge will not be able to pursue this matter any further because of his sickness. I think that's a good step in the right direction. That is but one. Two, if the matter is set down for the whole term, there are chances that they want to make up for the lost time to ensure that whatever inconveniences that would have been there, at least they do make up that time. Now, what is likely to happen is that if the new judge takes over the matter, it means the matter will have to start afresh. That's what is called the start de novo.
So you're saying there is a possibility, I didn't hear you correctly, there is a possibility, or it's at his discretion, he could in fact decide perhaps to read through the records because there are proceedings that were recorded?
Well, it doesn't usually happen where a judge reads through the records. Because remember, when the witnesses are testifying in the criminal proceedings, there is also what is called a demeanor. And we want to see that in the judgment of the judge who has been presiding over the matter. So the new judge that will be taking over the matter tomorrow did not have the benefit of the witnesses that have testified. He did not see them. He did not see their demeanor. He did not see their attitude towards the whole process of these proceedings. So that is why the whole process has to start afresh from a new judge who has been specifically allocated. And obviously, with the Deputy Judge President having taken over this matter, it means there's a likelihood that if it is not finalized in this term, he may again allocate this judge to deal with this matter because it's one of those old matters that has been there in the trial run. But remember, this also borders on the question of the fair trial. Fair trial includes a lot of things, a lot of interests. Balance the interest of the victim. The Meyiwa family has been waiting for this justice. It remains a pipe dream to them. But then you also have the accused persons. Some of them are incarcerated. They also have this dark cloud hanging over their heads. They cannot wait for this matter to be finalized. So that
and that is guaranteed. That is guaranteed in Section 35, subsection 3, particularly D, that you need to have a speedy trial here. So in this instance, it also is, for some, it could say it's prejudicial financially for them, because if you've got a legal counsel on brief, it's not legal aid. If you're going to start afresh, one would assume you've got to still pay the advocate, even though you're starting afresh. It cannot be for free.
Indeed, and it is not at their fault. Actually, both parties are not at fault in this matter. But it is fair enough to say, gentlemen, we need not to wait for Judge Makangela because it doesn't look like we'll come back anytime soon. Let me allocate another judge so that we can quickly deal with this matter. I think that's fair enough, that one. Remember, I'm saying both parties, the family of the victim wants to know what is happening. The accused person, they want their names to be cleared. Remember, whenever this whole situation, I believe that the Deputy Judge President also called the parties, they had a meeting, they could look at the options to say, okay, if you don't want a new judge, let's wait for Judge Makangela. What if he comes back next year? Because even though he is suspended, the condition is that the party head matters, those that are pending before him, he can deal with those matters to finality, which would include the Meyiwa case. But to say the judge, okay, now that we can see here's the trouble, let's rather bring a new judge so that we can avert any situation unforeseen that would happen in future that would cause this matter to delay. I think it does make sense, of course, if as it would happen where parties are called.
Let's look at the testimony now. We had cross-examination. In this instance, there's court record. Is it possible for some of the witnesses now to change their statements or the manner in which they answer questions? Because if we look at how Advocate Mshololo conducted herself during that period, she was one with very surprising questions. There was that element of surprise where she wants to see how truthful you are. But now in this instance, with the benefit of a second take, they would now know the line of questioning that would be coming from Zandile Mshololo or the case that she's attempting to build. So does that not add some sort of a spanner in the works?
Unfortunately, evidence under oath cannot be changed, cannot be altered, cannot be amended. That evidence remains relevant. The only difference is that now those witnesses will be telling the same story, but before a different judge. So,
but can they refine it?
Mshololo and her colleagues, they will be having that benefit of that information, because should they find some discrepancies, should they find that now there's something new that the witnesses are bringing that they did not bring earlier on, they ought to have brought, they will be able now to share that information with the judge to say, okay, this is what you told this court, this is what is happening now. It does not change. You take an oath. It does not change that, no, this oath does not matter before this judge. It only mattered before that one. So it remains an evidence there.
So meaning the record could be used as reference, the previous court record?
Most definitely. Actually, remember, even in the bail proceedings, this is what all the accused persons will be told, that whatever you say before this bail will be used in the trial court. So it does not change because you gave the evidence under oath in the bail proceedings. It cannot be used in the trial court. That information will be kept. It will be used to say, this is what you told the court. It means you are not a trustworthy witness. This court cannot take anything that you are saying seriously because you are changing, or whatever the case may be. The point is, same evidence before a different judge. It does not mean different evidence, different judges. It doesn't work that way. This is the same trial. These are the same charges. Witnesses will have to testify.
Sinawo, thank you very much for your insights this evening. That was legal analyst and director at Makangela Mtungani Inc, Sinawo Makangela.